It's a pleasure to be in Edinburgh. I was here 50 years ago, and it seems all the same. I'm really pleased to have the opportunity to interact with those that know what it's all about. And of course, that's you, it's not us in the committee. Sometimes I believe that the international human rights accountability mechanisms, they may seem a little bit remote. What do they in fact have to do with the reality here? And once we did a training in Jordan, who has also ratified the Convention Against Torture, and some of the members said, when we explain about that's all fine, but that has nothing to do with us. Oh yes, it does. We are not accountable to the international community. Oh yes, you are. And this is what Diego, of course, stressed, that these are not declarations. I mean, the Mandela rules, which you probably know, the minimum standard rules, they are in fact what we call soft law. They are not obliging. They are standards that you can say there's a moral obligation to comply with those standards, but not a legal one. But that doesn't apply to the treaties. And that's the strength of the treaty body system, the 10 treaties that Diego spoke about. That this is, firstly, it's a legally based system. State parties are obliged to actually implement the provisions of the treaties. And secondly, it's an independent system. It's not politically run. The members in the treaty bodies, the committees, are elected, and they are elected in their individual capacity. They're not representing anybody. I mean, I'm a Dane. I was nominated by the Danish government, but they don't have any instruction rights. I act completely independent. I can do whatever I want in the committee. And that is different to many other of the international human rights accountability mechanisms, those that we call the special procedures, for instance. We have a UN special rapporteur on torture, Professor Nils Melzer from Switzerland. And he is mandated by the Human Rights Council, and he acts as an independent expert. He can, some calls this the naming and shaming mandate. Maybe it is. And he can name and shame whoever he wants. But then the countries that receive this naming and shaming or recommendations have no obligation whatsoever to invite him or to take into consideration what he says. So that's essentially the difference between what goes on in the Human Rights Council and the special procedures, working group on arbitrary detention, etc., and the treaty body system, which we're going to talk about now. I was asked to give an overview of the Convention Against Torture in a context like Scotland. What does the convention mean in this setting? And to give a brief overview of the UNCAT reporting process, my figure actually looks quite a lot like Diego's, the cycle, so you'll get it once more. The role of NPMs and the impact in this process, and what the committee is looking for in submissions, and some examples of good practices of reporting from countries similar to Scotland. I made an effort to try to address those 4 issues. I wouldn't say that we gather good practices like that, but I did manage to find one example that might be of interest. We'll see about that. Why is the UNCAT, the Convention Against Torture, relevant? Well, this is because it's mainly about prevention. One might think that the Convention Against Torture, it prohibits torture. Torture is now prohibited. Yes, but that was done long before that. That was done in the Universal Declaration of Human Rights. It was done in the International Covenant of Civil and Political Rights from 1966, I believe. And that has long ago been established at what we call jus cogens. It's an international rule that torture is prohibited. The Convention Against Torture came in 1984. That means a long time after. So it doesn't sort of do the prohibition. That was done already. What it does is that it establishes obligations to state parties to prevent torture in a number of ways. And you could say, is that relevant when you don't have torture? Yes, of course it is. It's prevention of torture. So countries like Scotland, like my own, where we would say they are by and large torture-free. We might, in the corners of our society, find some dubious examples that are certainly ill treatment and might even amount to torture. But by and large, this is keeping the system free of torture. And this in fact means since also norms develop. One of my favorite examples is that 20 years ago in Denmark, when there were complaints over the police, they were investigated by the police. And that was sort of by and large the standard. The police, they investigated themselves. And then somebody started to say, isn't it unfair that the police is investigating themselves? And this is, of course, the basis for the independent police complaint commissions that have developed as a standard now. And nobody today would accept that it wasn't an independent body that investigated a complaint over the police. So we see the norms, they develop all the time. And in a way you could say that compliance with the convention ensures contemporary guidelines and respect of rights. That could be the right to lawyer from the very outset of the deprivation of liberty. From the very outset, oh yeah, what if you have legal aid? Can you actually manage to get a public attorney available from the very outset of the arrest? And if not, what are the consequences that the person is without a lawyer for a while? Maybe the interrogation starts, etc. So that's a relevant norm. Video recording of interrogations is also now becoming an international standard. But what about the recordings? Where do they go? How are they used? Are they made available, for instance, to the lawyer of the accused person? Are they reviewed by a superior or independent body that actually assesses whether the interrogation took place according to the book or not? So there's a lot of standards here that are developing gradually and that are relevant for countries like yours and mine. Investigative interviewing is now the new hot topic. The former special rapporteur on torture, Professor Juan Mendes, has now taken an initiative to do a universal protocol on how to do investigative interviewing. And what is investigative interviewing? It's a way of investigating for the police that does not build on the assumption that the person is guilty and we just need a confession. Because as you either know or can easily imagine, in many, many countries where torture is prevalent, it's because the police doesn't have a lot of sophisticated technology at their hand. They don't have DNA typology or fingerprint technology. They have one way, and that is beating the confession out of the suspect. And that's essentially the way, and then the court accepts this, and then the case is solved. And the investigative interviewing is a contemporary way of addressing this problem and having a much more sort of investigative approach in the interrogation and the investigation by the police. So the right to request and receive medical examination from an independent doctor. This basic safeguard, of course, came up because if a person is tortured or ill-treated, it can be very important to have it medically documented while the bruises, whatever, are there. And this can mean the difference between the complaint over torture being dismissed completely or being accepted by the public prosecution and resulting in justice. So there's a number of standards here that flow from ratification of the convention that ensures that state parties to the convention are actually up to speed in terms of such processes. Some of the articles that can be relevant in the Convention Against Torture is Article 1, which provides the definition of torture. And the idea is, you may know the definition, it has 4 components. We're talking about severe pain or suffering, mentally or physical or mental. We talk about intentionality, that this is not collateral damage, it's done with the purpose of creating this pain. It's done for a purpose that can be obtaining a confession or information, and it's done by a person acting in a public capacity. We would then expect that countries include or implement that definition in their national legislation. And very few countries actually do so. Why is that so important? It's of course important because the definition of torture was actually a novelty from when the convention was done, that for the first time torture was in fact defined. And we could agree about what we're talking about. It's not like any case of potential torture or ill treatment can be defined, graded by the definition, but nevertheless, this definition is important. And many countries do not have the crime of torture in their criminal code. And what does that mean? It means that when we ask a state, how many complaints of torture did you have? How many did you investigate? How many did you actually prosecute and punish? States are unable to tell us that. Most recently, we reviewed Russia, July, August, just a few months ago, and we had to say the same. They have different provisions in their criminal code. Well, this could also cover torture, and this is violence or abuse done by a public servant. But when we then look at the statistics, they are unable to tell us how effectively are they actually prosecuting torture. And this is one of the obligations of the convention. Article 2 provides a very broad obligation to prevent torture. We have in Article 10 that there's an obligation to train staff that are involved with detained persons. Inter alia, train them in the Istanbul Protocol, which is the standard for medical identification and documentation of torture. And we have my favorite paragraph, Article 11, which is, I'll go back to that, review of arrangements for arrest and custody. And we have an obligation also to prevent ill treatment. Article 11 says, each state party shall keep under systematic review interrogation rules, instructions, methods, practices, as well as arrangements for the custody and treatment of persons subjected to any form of arrest, detention, or imprisonment in any territory under its jurisdiction, with a view to preventing any case of torture. That's a rather wide-ranging obligation. The government has to look at the way they treat their detainees in all aspects, how they keep them, the detention cells, the overcrowding, the way they are interrogated, the way the interrogation is videotaped, etc., etc. So, by and large, and that's my point here, the UN Convention puts an obligation to state parties to prevent torture and ill treatment in many different ways. So this is then the committee. From the left, we have Patrice Gilibert. He's the secretary of the committee. Then we have Sébastien Tousset from France. He's a professor of international law. Then we have Felice Geyer from the US. She heads Human Rights Institute. She has been in the committee for 20 years. Then we have Diego Rodriguez Pinzon, a newly elected member from Colombia. He's a professor of international law at American University in Washington. Then we have Essadia Belmir. She is a member of the Constitutional Court in Morocco. Then we have Claude Heller. He is a former Mexican ambassador. He was ambassador in the Security Council and in the Human Rights Council. He knows any international political conflict in the world by heart. That's his. Then we have Anna Raku. She's a former member of CPT together with Alan. And she works for Terre des Hommes in Moldova. She's a lawyer. We have Abdelwahab Hani. He's an opposition politician and activist, he calls himself. I think he's also a lawyer, from Tunisia. Then we have Ms. Hong Chang. She's a human rights expert in the Ministry of Foreign Affairs in China. And we have Mr. Bakhtiar Tuzmuhamedov from Russia. He has been a judge in the International Criminal Tribunal of Rwanda and Yugoslavia. So these are the independent experts in the committee, and this is the committee that actually reviews the reports from the states. And here we have the same, more or less, cycle that Diego talked about, so you'll have it once again here. I will take as granted that we follow what we call the simplified, the simplified reporting procedure. And this starts with the list of issues prior to reporting. We have another list of issues that we call LOI, so that's can complicate things, but we call it LOIPR, the list of issues prior to reporting, which has been issued for the UK recently. I think, was it in 16 or 17? This is a list of the most important topics according to the committee. And it's like questions. Please provide or requests to the state party to answer. It's around 10 pages normally, of maybe 35, 40, 45 different topics. Then the state party submits its report, and this report is then the replies to the questions or to the topics, and nothing else. So it's not like the state is going to send a report on all the articles in the convention, but only those that were in the LOIPR. So, for instance, we can say, what has the state done to implement the definition of torture in its criminal legislation? And the state party says, well, we don't agree that we should put it in the criminal, we have a better definition than the one in the convention, and then they say, well, we don't want to do that. Then, based on the report, we have a dialogue between the state party delegation and the CAT. It's a 2-day session of Q&A. The committee has, in advance, appointed 2 members as rapporteurs for that particular country. The burden of work is far too big that we can all look into all countries. So 2 members have half a year in advance started reviewing the report, the shadow report, the material, doing research, and prepared a number of questions, up to maybe an hour of questions. So it's quite a lot of preparatory work that is done in advance. After that, CAT issues concluding observations, including follow-up recommendations. And what is follow-up recommendations? Because they are in fact all recommendations that the state party is supposed to implement. That is, we pick 3 or 4 of the recommendations from the concluding observations that we consider are the most urgent ones and have a characteristic of being protective in its, or prosecutorial in its nature. Things that we really believe the state party must do urgently. And then the state party is obliged to submit a follow-up report after 1 year. So we don't take out for follow-up recommendations that cannot be implemented within 1 year, which excludes, for instance, legislative recommendations. It takes more than a year to get a law through Parliament, etc. So they could rather be prosecute the perpetrators in a certain case, or ensure that there's redress provided to these victims, etc. And then when we receive the follow-up report, the follow-up rapporteur in CAT, that used to be me, now it's Abdel Wahab Hani, assesses and responds to the follow-up report with the agreement of the whole committee. Then when we do our next list of issues prior to reporting, of course those issues that have not been followed up properly in the report go directly into the list of issues prior to reporting. And that's what justifies this cyclic nature, because, and you'll get some examples later, we don't forget things. This is not a hit and run. It's very much a continuous process where we work with the state and other actors in order to push for the implementation of these topics. Entry points for civil society organizations, for national human rights institutions, and for NPMs are essentially the same. That is the possibility to submit shadow reports or inputs to the process. That applies, of course, as mentioned by Diego, to the LOIPR, that already when the committee is in the process of preparing its list of issues prior to reporting, then any input from shadow reports will be helpful and taken into consideration. Obviously, shadow reports as input to the dialogue on the state party report, that is, the civil society actors or NHRI or NPM have reviewed the state party report and may disagree or put things in perspective and put that into their shadow reports. When I reviewed the United States in 2014, there were 63 shadow reports. So you can imagine that the preparatory work in advance of such a dialogue is rather huge, because on top of that, of course, there's the state party report itself, other UN reports, other material that could come into play. During the session, CAT organizes private meetings with civil society organizations, with NHRIs or NPMs. I think we're the only committee that does it on a very regular basis for all countries. The day before we have the session with the delegation, we have a 1-hour meeting set aside with NHRI and NPM, and it's private to the degree it's not webcasted, it's not with access for anybody else. And we have 1 hour set aside for meeting with NGOs. And this, of course, is also a private meeting. Other than that, we also receive confidential briefing from UN, for instance, desk officers, etc. So we have for each country 1 hour for the NHRI and NPM, and 1 hour for the civil society organizations. We also have side events during the session. For instance, NGOs can organize an extra 1 or 2 hours of a topic, maybe in the lunch break, where there's a special, more in-depth briefing. That's an option as well. Maybe one of the most important roles of NHRIs, of NPMs, and of civil society organizations, I think, is to create public awareness about the CAT concerns, recommendations, and follow-up recommendations, so that once the concluding observations have been issued, that they are actually communicated as much as possible. You can even imagine, we had that in the case of Lebanon, that after the concluding observation, there was a workshop where the government participated, civil society participated, donors participated, and the idea was to develop an implementation plan for the recommendations in the concluding observations. Press could be there as well, and that would give impetus to the recommendations, because often they are maybe the same as an action plan for a security sector reform. That could in fact be the same. And some donors, the EU or the UNDP, might go in and fund some of that. That's of course not relevant here in the UK, but in many countries it is. And of course we receive shadow reports before the assessment of the follow-up report from the government. Once the government has come back on these 3 urgent recommendations and said, we have done this and we have done this and we have done that, it can be very useful to have alternative views and reports here. Going through a little bit, how are we time-wise?
20 minutes.
Fine. If we look at the national human rights institutions, as for all 3 types of organizations, there's a 2-way street here, because CAT may support the National Human Rights Institutes by putting questions to the government into the mandate, to the resources, and to the independence of the National Human Rights Institute. And we do that all the time. It's almost a routine assessment that we address the functionality of the of the National Human Rights Institute in any country we review. The National Human Rights Institute, on its hand, may contribute with information about, for instance, problems regarding its own mandate, funding, and independence. But most importantly, what is, according to the NHRI, the most pertinent problems of human rights in law or in practice. Some human rights institutes, I understand, not the UK, actually receive complaints and can inform the committee about complaints over torture. How many complaints were there? How were they processed? How were they investigated? Did they give rise to any prosecutions? And recommendations made and subsequent compliance by the government. For instance, that they have made recommendations on legislative issues and this was or was not complied with by the government. And of course, the shadow reports may put into perspective or even correct the state party reports. National Human Rights Institutes, as I just say, may participate in private meetings. If we look at the role of the NPMs, it's more or less the same. CAT can inquire into the mandate, to the resources and the independence of the National Preventive Mechanism. In particular, for instance, its access to sensitive places of detention. For instance, intelligence services, detention places, or military places, which are often not the first one that is in the mandate of the NPM. The possibility to do visits without notification. In some countries, this is a problem. And the number of visits that they actually do. So a standard part of the CAT review will also be an assessment of the functionality and the setup of the NPM. Is it independent? Is it competent? Does it have the resources? Does it have the mandate? And does it actually function the way it does? And does the recommendations, the last bullet here, the recommendations made, are they complied with by the government? How much change is actually created by the recommendations made by the NPM to the authorities, either at the local institutional level or at the systemic national level? Thirdly, more or less the same with the civil society organizations. CAT may inquire, and we do all the time, into the freedom of operations for civil society organizations, the civic space, which we all know unfortunately are shrinking in many countries, including reprisals against human rights defenders and journalists. I do not assume that this either is relevant here, but it's a standard view of the committee to push for the freedom of operations for human rights NGOs that in some countries are considered enemies of the government and not a constructive, critical counterpart to the government, which it should be. And again, of course, the civil society organizations in their reports might contribute with problems regarding freedom of operations and what are, according to civil society organizations, the most pertinent human rights problems in the country. This is an example from Venezuela, a treatment center. You may not be able to see the figures here, but I can tell you what it is. It's a rehabilitation center for victims of torture that actually registered systematically who was the perpetrator of the clients that they were treating. And then they registered from which branch of the police or intelligence were this perpetrator. And it was very evident that the vast majority of their clients were tortured by members of the scientific police, which is a name for the intelligence, the police intelligence service. And of course that was a very helpful information for the committee, because we could now pinpoint the questions to the government about what is the accountability of the scientific police, what's the structure of it, what do you intend to do to prevent them from continuing to torture your citizens? That was one example. Another example have been, I unfortunately don't have them here, but I don't think we have time either, that we get videos submitted. When we reviewed Ecuador 1 week before, an NGO submitted a surveillance video from a prison where obviously the prison guards were torturing by means of electrical discharge weapons and batons. It was very obvious, and I asked the head of delegation, that was the Minister of Justice, with all concern that this can be fake or not true. What's the government's opinion? Well, we know it's true. It was, and we have taken action. But it only shows that the video surveillance works. And where we had to disagree and say it didn't work, because we got this video and nothing has happened until now when it has been made public. Exactly the same happened when we reviewed Russia a few months ago. 1 week before, there was a video released, a 1-year-old video, again it was from a body-worn camera of one of the prison guards, where 17 prison guards were torturing one prisoner with phalange, and it was a 10-minute sequence. You may have seen it in YouTube. It's easily accessible in YouTube, and that created a necessity for it was a deputy minister of justice that was heading the delegation to right away be able to say, we have arrested them all. And all the prison guards have now been arrested, and where the committee could say, that's fine, that's a very good beginning, but we put it in as a follow-up recommendation to brief us in 1 year's time what has happened in these cases. Have they actually been prosecuted? Have they actually been sentenced? Because as we know, many of those cases, they start up and they start maybe fine, and then they are dismissed, or nothing happens, but so we have the opportunity here now to follow up on what will happen with the 17 prison guards. And this is, of course, just one symptom of a system that is not sufficiently. They don't have an NPM. And that was one of the things I was going to say. The UNCAT, as Anna explained, is a very effective way of preventing torture that you go out and see. But there are countries that would never dream of ratifying UNCAT. That applies to the United States, to Russia, to China, to Venezuela, to Israel, and many others. But we have them in CAT, and that shows the complementarity of the different anti-torture mechanisms in the UN, that these countries have ratified the Convention Against Torture. They are up for scrutiny by the Committee Against Torture, and that's good, because Russia doesn't have an NPM. They have some public commissions that go out and look, but they don't have the strong mandate that UNCAT prescribes for the NPMs here. So what are useful alternative reports to the Committee Against Torture? And I have to start with saying that they are short. And the thing is, we all work voluntarily in the committee. We don't get a remuneration for it. The committee meets 3 months a year in Geneva, and we have at least the same preparatory work. That means 6 months, that's half time, on top of all of us having full-time jobs. So there are limits to how much we can do, and it's not only country reviews. We do a lot of other stuff. So it is important. I can simply say that a 5-page report has 10 times bigger chance to be read and used than a 50-page report. That's the way it is. And I can just as well be honest about it. So, but you know the slogan or the saying that I wrote a long report because I didn't have time to write a short one, right? And it's essentially the same here. Focused. There's nobody expecting that all NGOs or NHRIs or NPMs addresses everything. Not at all. It's very fine addressing one thing, and 2 things maybe, that are the most important ones. And it would also be nice if the committee members can see what, according to the authors of the shadow report, is the most important. If we only have room for one more thing, because when we read the shadow reports, we have prepared ourselves. We have made maybe a 25-page manuscript with all our questions, our motivated thing. And then at the very last moment, a few weeks before, we get the shadow report. So maybe there's only room for bringing in 1 or 2 topics. And then it's helpful to be able to see, we think this and this is what you should actually try to include in your questioning, because this is the most important. There's not a generic form that should apply. I give after this an example of one form that as a format that I think can be useful. Yeah, the sooner the better it's submitted. Of course, it gives us more time. I think we have a formal deadline of 4 weeks. 22nd of March. Anna knows. Thanks. But before that is, of course, helpful as well. Some NGOs that come down, they hand over the report in hard copy, and I must admit it does have an impact. We have gone paper smart, as they call it in the UN, meaning that these 1 meter of documents that were normally waiting for us every time we came to a session, they are now not there anymore. We are supposed to go on the extranet and pull down what we... But some members, I will not mention names, some members have not gone paper smart and insist on having at least a part of this 1 meter of documents. So sometimes when you're given this report, we are all human beings. We may have another look at it than if it's just somewhere in cyberspace. Coordinated reports is really an asset. I mentioned that there were 63 shadow reports from the US, and one of them was actually coordinating, I think, 20 or 25 NGOs. That was very, very helpful, because then we do the same in Denmark, and actually Dignity plays a role in coordinating among the NGOs, and that is helpful. Reinforced in the private meeting, obviously, when we have the opportunity to meet, it's good to make the same points that were the priority points in the report. That goes without saying. It can be operational. That is very helpful. That operational, what do I mean? I mean, they actually propose questions and they propose recommendations or concerns, so that in principle, if the committee member agrees, you could take it right away. Say, this is the question that was posed. I do that once in a while. If there's a very good question in a report or concern, you can take it right away or make it your own one way or the other, so that it's useful. You can use it right away. You don't need to process a lot. Yeah, of course, drafted in a language that is mastered by the rapporteur. That's a good thing as well. I don't know if you know the American Civil Liberties Union, ACLU. It's one of the most professional human rights NGOs, not internationally oriented like Amnesty and Human Rights Watch, but only oriented towards the US, and they're extremely professional. And they made a shadow report. I'm sure it's publicly available on our intranet, so you can go look if you want. And they structure all of their paragraphs according to this. There's first an issue summary of facts, then they resume what CAT has said previously in that topic. They say what was the US government's response to that topic. Are there any other UN recommendations, for instance, from the Human Rights Committee or CEDAW or CRC? Then they are put here. And then recommended questions and suggested recommendations. I mean, you see how digested it is. It's extremely digested. It's not like, now we are writing a report on the human rights conditions in Russia. It's quite different. It's very processed and easy to take. If you have it's also more demanding, of course, but if you have the resources to do it that way, it's really helpful. The last point I have is an example from a country that resembles Scotland, and I think you compare yourselves with the Scandinavian or Nordic countries often, so I took Sweden here. I cannot do such an example without reading a lot of text. I'm sorry about that, but it doesn't make sense if I just do it in headlines. So I just have to read a little bit here. We said to Sweden, please comment on the concerns expressed by the Committee on the Rights of the Child. See, we work together. So we see, as a part of our preparatory work, we see what did the Committee for the Rights of the Child say to the to Sweden. And they say that under current rules, it's possible to isolate children in youth detention centers if they display violent behavior or are affected by drugs to the extent that they jeopardize the general order. In this respect, please provide information on the steps taken to implement the committee's recommendations, that is, to review the current practice of solitary confinement, including amendment of current legislation as appropriate, to limit the use of this measure to very exceptional cases, to reduce the period for which it is allowed, and seek its eventual abolition, and to ensure that all children who have been taken into custody are provided with adequate legal representation. And please note, the question was, steps taken to review the current practice of solitary confinement. That was the question. What does the State Party answer? They say, Section 15C of the Care of Young Persons Act states that young people in special youth homes may be placed in a special isolation room if they use violent In 2009, the government gave the National Board of Institutional Care, the state agency that runs special youth homes, the task of reviewing the application of isolation and reporting planned and ended measure, as well as making suggestions for improvements. The SIS report on the use of isolation shows that both the frequency and average period of isolation have been reduced. Fine. So they've done what we asked them to do, and apparently the result is fine. Then we get a shadow report from the Ombudsman for Children in Sweden that says, seclusions in special institutions shows a renewed increase since 2012. And they refer to the statistical yearbook of this SES. And if you look at it, you can clearly see that suddenly, yes, the frequency and the duration of the seclusions of kids in these youth institutions have increased again. Children suspected of crime are held in police cells and remand prison cells. And okay, kept in police cells, well, yes, but the problem is, of course, since we cannot mix minors and adults, they are often, they cannot be together with the other detainees in the police station. And that means they are de facto isolated between 22 and 24 hours a day. And even more, they said data about detained children are incomplete. More children are being detained. They actually did a thematic investigation into the detention of minors, and they counted the cases that there were more than 3,000 incarcerations of children in 2011. Figures that the authorities did not have. Then we issued concluding observations and said, in particular, I have to make excerpts here, of course. In particular, the committee remains concerned at the application of such restrictions, including isolation to minors in police cells, remand prisons, and special residential homes. And the committee urges the state party to abolish the use of solitary confinement for minors and set up a juvenile justice system in compliance with international standards. And we included that in the urgent follow-up recommendations. So 1 year later, when the state sent its follow-up report to the committee, it says, finally, it's worth mentioning that the government has already tasked the Swedish Prison and Probation Service with the implementation of a special initiative for young people over the course of 2013 to 16, in order to find forms for measures that specifically target young people while also relieving their isolation. The Prison and Probation Service is implementing early interventions targeting young people in remand. The ambition is to give the pre-trial detention period more content and for these young people to be subject to interventions that improve their circumstances once they leave correction camp. The matter is not solved, but it may be in a good development, and certainly we are going to follow up next time. This is very clear that they have sort of give some indications here that they are working with it. They have taken on board that we're not just talking about residential homes, we are talking about the general criminal justice system. And they seem to be willing to take it on, work with it, and task the prison and probation services to improve the conditions. And that's good, but we have been pushing it. So it came from the CRC, the Committee for the Rights of the Child. It came into CAT. The Children's Ombudsman contributed, and we made a conglomerate recommendation. We made it urgent. They went back with initiatives. So I think that's an example of how working together with here is the Ombudsman and the CAT can actually evoke change. Sometimes I like to see the process here that it starts in the country with the NHRI and the NPM and the civil society that brings the topics to CAT. CAT processes it, sends it back in concluding observations to the civil society, NHRI, NPM, that continues to work with the CAT recommendations, and that we have a synergetic way of collaborating. That's the way I like to see it. All right, thank you.